click that. As we start to reimagine new ways of looking at issue resolution for families, I very much hope that the legal fraternity will stop using the term private law to describe all family separation issues. We want to be much more disciplined, I think, going forward, that really private law is just that relatively small cohort of cases that go into the court. And we need to, as the Family Solutions Group have emphasised in their extremely good report, we need to reframe not only how we look at issue resolution for families going forward, but also to start using new language. So instead of private law, generally I try to use the word issue resolution, not even dispute resolution, but issue resolution, because I think that better encapsulates the full range of resources that are available to separating families to sort out their issues. In a sense, quite apart from the important convenience for me of being able to speak to you before I start my list, it might be helpful really in a sense for you to contextualize where we have got to in thinking about how we might want to reform private law and issue resolution going forward. And so why will we remember 2020? Well, in very many ways, I think that 2020 will be marked in history for, of course, for the pandemic. And many people will say it was the forgotten year. It was all the year we didn't have holidays. It was the year we didn't see people. It was the year when things didn't happen because we were locked down or subject to very tight restrictions on our world. I wonder if I could just remind you just to keep your microphones on mute, otherwise for everyone else it's just a bit of interference there, I think. But for those of us who have been thinking about the way in which we might want to reform the way families resolve their issues post-separation, 2020 was in fact an extremely productive year. And I've summarized on this next slide, which I hope you can see, some of the things that were going on in this period. So just to quickly run through these initiatives and activities. Of course, in March 2020, the Private Law Working Group published its second report, The Time for Change, The Need for Change, The Case for Change. And that report principally looked at the way in which we felt in the Private Law Working Group the resolution of disputes within the court system could be improved. And we were extremely fortunate to have Tracy Sortwell on our group, who is of course going to be your next speaker, who brought us valuable insights from the perspective of the magistracy to that work. And I'll return to that work a little later. What, of course, we didn't really do, because it was essentially a court-based group, is we didn't really look and didn't have the expertise to look at the hinterland around the court. And so I set up the Family Solutions Group. One of the singularly the best things I did was to invite Helen Adam, who many of you may well know, to chair that group, who is an inspiration and force for good in the mediation community, I strongly believe. And she brought her extraordinary energy into that group, assembled a brilliant team, and prepared this report in November of last year entitled, What About Me? As I said a moment ago, this reframed really how we look at issue resolution for families outside of the court system, with a particular emphasis on children who are all too often, unfortunately, caught up in the crossfire and whose voices don't get heard above the cacophony of adult argument, and hence the title. So that was a really important report, and all those of you who were able to kind of see how that was launched, the president of the Family Division heralded it as an extremely important document that had brought together a range of thinking for over many, many years. So, and it's important actually that I emphasize that to you, the mediation community, because there we had the president of the family division, the head of family justice, saying this is one of the most important reports that has been published for a very long time. The Ministry of Justice Harm Panel published its report in July of last year. Of course, this shone a spotlight on the way in which the system, and I put it in inverted commas, if you like, the system is failing the survivors of domestic abuse and their children, both in and out of the court, but more particularly in the court system. But it has enabled us also to think very clearly as we go forward to how we should ensure that survivors of domestic abuse are properly served out of the court system and swiftly accelerated into and through the court system in a safe way, should that be required. With the pandemic swamping the court system in the spring and early summer of 2020, the president of the family division published a document entitled The Road Ahead, which was his attempt to encourage those in the justice system to think about how they could best streamline their activities to ensure that resolution of disputes within the family justice system were done in the most efficient way. But I reference it here because, of course, one of the things that the president had particularly emphasized was the importance for all judges, whether magistrates, district, circuit or high court judges, to think about non-court dispute resolution as a way of resolving disputes. And of course, within the early part of the lockdown phase, again, the private law working group quickly devised and launched, with government support, a range of proposals to try to relieve some of the pressures on the system. And one of those involved, in fact, a rebate of the application fee if parties were able to resolve their dispute, which had been essentially COVID related, before it ever got to in front of a judge. It was not, in fact, an initiative that was very well advertised or indeed taken up, but it demonstrated at least some good broad thinking and support from government on initiatives to take people away from the court system. The Nuffield Foundation, and I know you're going to be hearing from Lisa Harker, so I don't propose to steal her thunder right now, but the Nuffield Foundation published, first of all, Who's Coming to Court in Wales in 2020, and that was followed by Who is Coming to Court in England, which was published in February of 2021. And Lisa will tell you obviously a great deal more about that very interesting, very revealing research that was done in relation to private law and the very clear links between economic vulnerability and deprivation and the number of applications to court. And for example, the Northeastern Circuit, which is the circuit for which I have responsibility as a family division liaison judge, which has very high levels of social deprivation, also has high numbers of private law applications. So that was a very clear illustration of the link between the two. And I think for you, the mediation community, that's a really important societal context for you to think about your work and about how best to access those who are in those socioeconomic disadvantaged groups in order to try and entice them away from court and to reframe the way they think about how disputes or issues can or should be resolved. Away from the industry of the thinkers, if you like, around issue resolution. Of course, in Parliament, two very important bills went through. The Divorce Dissolution and Separation Bill, introducing no-fault divorce, which was, I don't think it's an underestimate to say, a real milestone in terms of our whole approach, our system approach to issue resolution, and it taking away for the first time the terrible blame culture that had been the hallmark of the previous legislation, and really, in a sense, recasting the whole question of divorce or dissolution or separation in a blameless way, which is extremely important for us. And of course, the domestic abuse bill still reaching its final stages, but again, giving some prominence to the steps that need to be taken to protect survivors of domestic abuse. What else happened in 2020? Well, I suppose it's pretty obvious that first of all, the pandemic exposed and exaggerated the inefficiencies in the family justice system, and whereas the system had creaked in the past, it really showed deep cracks when it was put under the sort of pressure that it was through the higher volumes of private law cases. And after initial dips, it's a sad reflection, but the numbers of applications of private law cases coming into the system rose and rose during the course of the year, to the point where the justice system itself is now under intolerable strain. The sad reality is that we simply aren't able to dispose of or reach to conclusions on, to put it another way, the number of the same number of applications that are coming into the court. So we are inevitably building up day by day, really, a significant backlog. And so all of the reports that I've just referred to were pulled together and reviewed by a Ministry of Justice-led body called the Family Justice Reform Implementation Group. And that itself then broke down into a private and public law working group. And then the private law working group became then the private law advisory and pilots group, because what really we wanted to do under the umbrella of the implementation group was to advise the implementation group and ultimately the Family Justice Board on how we would implement some of the reforms that have been recommended in the reports, and how we could then pilot them. So who's on this group? Well, there are representatives of Ministry of Justice, senior civil servants. We have members of the judiciary at all tiers and legal advisor. We have, of course, representatives of Welsh Government and Cafcas Cymru, just as we have a representative or representatives of Cafcas. We have representatives of HMCTS, and we are greatly assisted by Jude Eyre of the Nuffield Foundation as well. So we have a core there of those who are particularly concerned with the administration of justice within the court system, and that is the primary focus of our work. What we have, in fact, persuaded Ministry of Justice to do is to dedicate some of the funding that's been made available for us to procure a systems change lead to help us to design the whole world of issue resolution for separating families. This in itself is actually quite an innovative development for MOJ, who at a time when money is not widely available, have literally bought into the idea that we do need to have some real radical thinking about how we look at issues resolution. And just to give you a sort of a clue about how we see that, we've had some really interesting discussions with a systems change lead who has done some really valuable work in reforming the way in which mental health services are delivered to those with mental illness in the north of England, north and northeast of England. And what that team has done is to take a step right back from how mental health services were delivered in the first place and say to themselves and to those who deliver it, okay, well, this is what you deliver, but let's look at it through the eyes of the mental patient. What do they need? Let's take the to use the jargon, the user journey, if you like, for the mental patient, with mental ill health, and what do they actually need, and how best are they going to be able to access it? And in a way, by turning the issue round from what can we offer to what do they need, actually the delivery of mental health services was very significantly reformed to very great benefit and advantage, not only to the mental patients, but also to those who administer it. And that sort of conversation has made us think, well, we need exactly the same sort of approach here. We need to design our arrangements for separating families very much through the eyes of the user, of the child, and not just say, well, we can offer you this, but actually what do they need? And I think that that's a very valuable exercise. So we have a systems change lead to be appointed within, I hope, a matter of weeks going forward. And of course, within all of that, so our discussions on the group, our involvement of the systems change lead, we're also involved very much with consultation and liaison with the Family Solutions Group. And also recently, we spoke with someone from Alberta, Canada, a former lawyer who is leading up their Reimagining Family Justice initiative there, which has so many similarities to what we're thinking about here. And it was extremely useful to get her take on where we are. And we will continue to have that dialogue with her because she's about 2 years ahead of where we currently are. But very many similar issues arise there as arise here. And last but not least, the Nuffield Family Justice Observatory have extremely generously agreed to fund research for us in relation to the user journey by taking those who access issue resolution services, either both out of the court and in the court, and help us as we go through this process of redesigning issue resolution for families, how it is playing out on the ground. I am led to understand that the research team is on the point of being appointed, if indeed it hasn't now been appointed. So that's a very exciting development in this project. In terms of how it's being taken forward, it's an Ministry of Justice funded project under the last spending round. Unfortunately, of course, for all public services, only 12 months was committed by our Chancellor. So we have 12 months of funding for this project. But given the priority which I detect the government gives to this work, a ring-fenced sum of money has been provided for the private law reform initiatives. It is, however, to be a 2-year plus project. And so we have to very much hope that within the year we can demonstrate sufficient change and engagement with the project that the government continues our funding beyond April 2022. The project is administered by Ministry of Justice with good dialogue across government departments. And that's a really important point because DFE, the Ministry of Health, DWP, all of these other government agents or ministries have a finger in this pie, have an interest in family solutions and separation issues. And so it's really important. If we can't have, as the Family Solutions Group suggested, and indeed as we put to the Family Justice Board, what will be much the best is that we have a ministry for families, that we should at least have some better joined up dialogue and thinking between the government departments. And what we have proposed is to, as we go through our design phase of the project, we decided that we would bring in an English and a Welsh DFJ, designated family judge area, to assist us, to advise us, to test initiatives as we go, so that we don't sit in Petty France or wherever it might be at one of the ministries discussing all of this and then roll it out. We would actually roll it out with courts and services on the ground being involved step by step. And we have Dorset and North Wales as our two pathway areas. And they, of course, can then also provide us with really important information around local need, local availability of services, how best to harness it, and so on. There are three core themes which really underpin our work. The first is the promotion of non-adversarial problem solving. This, of course, is your bread and butter, and so none of what I say will be revolutionary to you, but it will be pretty revolutionary to those who work more intensely in the family justice system. Again, taking the position of the separating family at the outset. What do they need? Well, first of all, they probably need better information and support at the point of separation. And so one of our early building blocks of our work is thinking about how better information and support can be provided. We want to look at how we can enhance the network of services outside of the court. And you will remember, I hope, if you read the Private Law Working Group report, I'm sure you all did, that one of our key recommendations was the formation of supporting separating families alliances of third sector agencies, mediations, arbitrators, domestic violence, support groups, dads groups, you name it, in the community, and ensuring that, in a sense, they formed a cohesive alliance so that referrals within the alliance would be swift, and that if a party accessed one part of the alliance, it would be very easy for them to be diverted to other parts of the alliance. It's interesting to observe that these alliances were set up in Dorset and in Kent and elsewhere, actually, following on from the Private Law Working Group report. And one of the really interesting things that arose from this was that at the early meetings of these alliances, which were often convened for convenience only by the designated family judges of the areas, who invited agencies from their local community into a meeting room together in those good old days when there were meetings around a table. And many of the agencies looked at each other and said, I had no idea you existed in our area. We didn't know that you were around the corner from us. Really the first half hour of the first meeting demonstrated enormous value on its own, because it enabled people to introduce themselves to each other who didn't really know each other. And it seems to me that the mediation community, if you are not in an alliance or forming an alliance with other agencies, you absolutely need to, because going forward, and this actually links in with the Family Hubs initiative, the Growing Up Well project, which is a really good initiative of government, and we think has very much scope to be developed for separating families. But it seems to me that the mediation community needs to make sure that they are absolutely in the family hubs, in these alliances, so that referrals can be made swiftly and efficiently and effectively to mediators within those groups. Within this phase, we're trying to break down the silo working, which was a concern very much of the harm panel report, and to devise, and this is one of perhaps our most exciting initiatives actually, effective triage of cases before a court application is ever issued. Now, I'm not going to take up time, which is diminishing, on the subject of MIAMs, because you all know about the MIAMs all too well. The MIAMs have not been, I would suggest, as successful as they should have been and could have been. And I know all too well from where I sit in the justice system that MIAMs are seen as obstacles to get over, not opportunities to take up. And I very much hope that there is still life in the MIAM, and indeed the Private Law Working Group recommended as much. But what we have considered is to, and are thinking about, though this is not by any stretch of the imagination a firm cornerstone of our proposals yet, so don't take this away as a done deal, it isn't. But what we're thinking about very carefully is bringing forward the opportunity that people have to have some professional triaging of their issues before they issue a court application. And one of the ingredients of that is a consideration of whether CAFCAS, for instance, could, and it would need primary legislation change, so it's not going to happen overnight, but whether it could fulfill a role in the pre-court space to do that triaging. And I'm led to understand that the Family Mediation Council are already in discussions with CAFCAS about working alongside CAFCAS in that sort of activity. But it seems to us that if one can have some, whether it's through the Family Hub or elsewhere, if one can have some effective triaging before an application is ever issued, we may well be able to harness the best of the out-of-court dispute resolution service. And from our point of view, the benefit is, of course, fewer applications then come in to the court. And the ones that do come into the court are the ones that need to come into the court, not those that don't need to come into the court. And one of the, perhaps I come to this on a separate slide, but I'll just say so now. One of the findings of a CAFCAS-led pilot that took place in Manchester 2 or 3 years ago was that once a case comes into the court system, it's much harder to divert people out of the court system into mediation or other forms of non-court dispute resolution. Once they've made their application, they want their day in court. And so that's why we see it as very important to try and to grab them before they make that application. We think that there are still need for better integration of out-of-court services with the court service. That's a training issue for the judges. And it's also, I think, around making sure that the alliances or the hubs are such a feature of our community outside of the court space that the court space, or the courtroom, if you like, is simply just a part of this range of opportunity or activity, rather than what it currently is the one resource that many people know is available for dispute resolution, and then a range of other unconnected services in the kind of space outside the court. And so integrating of our services is really important. We are urgently, and in fact, one of the first things we're really looking at is pursuing what was a very clear recommendation of the Harm panel, actually, the investigative model of problem solving within the court system. And the Ministry of Justice and CAFCAS have separately looked at how we can try to tone down the adversarial nature of family court process by making it more problem solving, making it more investigative. And we very much hope, and it's certainly our ambition, and indeed I was emailing on the subject only earlier this morning to my colleagues on the advisory group, we're very hopeful that by the end of June, we will be in a position to have a template for an investigative model within the court And that, of course, dovetails very nicely with your work, which is much more investigative and problem solving outside of the court. So as I hope you can see, what we're trying to do is to synthesize better what happens in court and what happens out of court, which will in itself, I think, help to lower the barriers between the two systems, the justice system and the out of justice system. So the next issue is the effective management of cases through the courts. And I'll take this reasonably swiftly because although it's important to us, it's perhaps of less importance to you, the mediation community. But I think it's important just for you to be kind of aware of what's going on, and because it is relevant. The first is this. I talked a little about the pre-court triage or gateway, and one of the issues we talked to the Alberta team about was the challenge that they received about access to justice. Is access to justice being denied if a triage gateway is being imposed on people before they can make an application? And the Alberta team said, well, you really need to think about what access to justice is. Is it a system, a process, or is it substance and solution? And actually, we lawyers think about access to justice as a process or a system. But most people think about access to justice as I want a solution, I want a result. And so actually there is no defeat of access to justice through early triage because we are actually offering solutions in a different way. Once court cases have got into a court, we are then contemplating, after safeguarding, a second triage phase, then to progress cases by reference to their complexity and characteristics rather than simply by reference to the date on which they were issued. At the moment, as you know, there's simply a single track road. Every case takes its place in the queue, whether it's complex or simple, and with obviously exceptions for the urgent cases. And we think that there is a much better system to be devised, which triages cases by reference to complexity and characteristics. If that ends up, at least at the moment, in the transitional phase, holding cases up, there is due to be launched, I'm pretty confident, next month, the facility for the gatekeepers to direct families to state-funded SPIPs. Of course, that would ordinarily only be ordered by a judge, before they ever get to a FHEDRA or early hearing. And that again will be, we think, a very valuable new development because it does help. I mean, SPIPs have been shown to help people to understand how better to resolve their disputes. I've talked about the Manchester pilot, so I won't go back to that. And so far as the multi-track routes, what we have very much in mind is that there are those cases which don't raise safeguarding issues, which actually probably shouldn't be in a court at all, which are capable of early resolution, and they can be accelerated swiftly to an early resolution appointment, possibly without the filing of evidence, and dispatched. There is, sorry, there's a typo there. It should be returner cases, not returnee cases. Returner cases, which occupy about 33% of our cases, they should be put on a different route because they probably require management by the same judge who heard the case, and then the others. But if we're able to take the early resolution cases and the third of returner cases onto different tracks, it frees up a lot more space to deal with those more complicated cases which form the balance. The third of our core themes is children and families first. This, of course, is one of the core challenges and opportunities for you, the mediation community, it seems to me, to ensure that voice of the child in mediation becomes standard practice in the right case, in the relevant case. And again, it's an important qualification, if you like, for the judges to see that mediation and other forms of non-court dispute resolution actively involve the child, as we would in court want to know what the ascertainable wishes and feelings of a child are before we make any child arrangement order. So we would be very hopeful that that is very much taken account of in all non-court dispute resolution. And of course, the second challenge for us and for you is to ensure that as we respond in the family courts, and as you should respond out of the family court to domestic abuse and other serious offences which arise on family separation, we respond consistently and safely for families. None of this, of course, is going to change overnight, and I hope that in the quick snapshot of where we've got to and what we're doing and who's doing it and why, you've got some idea of our vision. What we have very much in mind is that when families separate, there are a large number of issues which arise. There are the social issues, there are the relationship issues, there are the financial issues, there are the parenting issues, and there are the legal issues. And actually, if one thinks about it, it's probably only the legal issues that should be in a court, and all the other issues should be dealt with somewhere else. And so what we need to now try and develop is a cultural shift in how people think about separation through public education, to enable them to see that there are ways other than court, effective ways other than court, of resolving their social, their relationship, their financial and their parenting issues, but not in a courtroom. And so we need to, it's incumbent on us, the judges and those in the court system, to demonstrate that we can reframe the experience for families within the court system, but it's also incumbent on all those outside of the court system to demonstrate that the experience that separating families will have of issue resolution is truly effective and safe, and enduring. And of course, that is, as we've discovered through our research, so important. We don't want, in the family justice system, returner cases coming back again and again, and many of them do. We want the arrangements to be enduring. And we believe that enduring arrangements are those, generally speaking, for which couples have taken ownership. And ownership is better achieved through non-court dispute resolution. And so that is why we say that as we roll out our reforms, our reimagined system, it should be accompanied by public education and a change of culture to enable people to think differently about what they do. So my message to you is stand ready. There's lots of opportunity and there is very much challenge ahead. I hope you found that helpful. Thank you very much indeed. Mike, over to you, but I think you're on mute. If you, there we go.
Right, we got rid of that. I think we're all there. Right. Well, thank you, Judge Cobb. That's a really helpful and interesting sort of oversight of where the whole legal world is going and the direction it's going in. I'm gonna sort of, I know we've got very little time before you have to run off to court for the day. I just want to pick up on one point that I think is an integral link to this, which is we've trained magistrates in mediation in 3 different courts. We've trained legal advisors in other courts all about mediation, and we found the level of knowledge across the court system is very low, to the point where no magistrate that we've trained has referred a case out to mediation, where legal advisors don't understand the difference between a mediation session and a MIAM session. So just wanted to get your take on how do we get the legal services, and especially legal advisors, because I know they're, as a sitting magistrate, I know how important they are in running the court and making referrals out to things like mediation. How do we get the legal world understanding mediation better?
Well, Mike, I think that's a really good question. And indeed, as I've been involved in thinking about private law reform for almost as long as I've been on the bench, because I was the original author of the Child Arrangements Programme and involved in much judicial training, it is a source of very considerable exasperation and frustration to me that what you have described is also the experience that I see and hear about a lot. And it is obvious, I think, by your question that there is going to be no overnight solution to the issue that you have raised. But I genuinely believe that what needs to happen is that we do need to form these family hubs. We do need to form these alliances. I say we, society needs to. There needs to be a structure for establishing family hubs and alliances in each community, which can then demonstrate their collective worth. I'm quite sure that the sum is greater than the sum of the parts, if you like. The whole is greater than the sum of the parts, because it will then show the court system how effective the availability and the delivery of dispute resolution out of the court can be and is. And if mediators are part of that, as I encourage you to be, then it seems to me that that is the best way of demonstrating, if you like, the value of mediation. And it will also, I think there are two other issues. I think that partly at the moment we all operate in silos. So we operate in a justice system, and you operate in a non-court dispute system. And we need to kind of break those barriers down more. And I think that, again, raising the profile of alliances of services will help to break down the barrier between the two. There may be other ways. I think the other point, which is one that vexes us very much, is the cost issue. And it's one for which there is no easy solution. I don't admit there is. But actually, the court, what people get through the court system is, on the whole, pretty good value. For a court fee, they sometimes get days and days of undivided judge, Kafka's professional attention. And I think that the cost of mediation it is a disincentive, and indeed, of course, it is in some respects impossible or extremely difficult for some families. But I think it's also, for others, it's a disincentive. And I strongly believe, and I've had these discussions with the Ministry of Justice and will continue to have these discussions, that until there is some wider availability of support for mediation, government support for mediation, we will never really be able more effectively to break down these barriers. It seems to me that the solution does not lie in raising court fees. The solution, to some extent, I think, lies in how we can manage better the cost of mediation to families who would otherwise struggle to afford it. I appreciate that that's probably quite controversial, but it's nonetheless, I think, a real factor. And I think I don't pretend to have an answer to it, but I think it's important to call it out.
I think the cost of mediation is relatively low when you compare it to other legal options going forward. We get so many phone calls where someone spent £20,000 with solicitors and then come to mediation at the end of that. And it's disappointing when you hear that. And we do now have a voucher scheme. It's interesting to see the long-term view on that. We've been accessing it. But I'm quite worried about the decline in the number of legal aid providers. I think that's something that we've noticed quite a significant drop off of legal aid providers. So there's a number of mechanisms available that we need to probably make more appealing for mediators to use. How do you view the legal aid sort of side of mediation in the long term?
I'll just pick up one point, Mike, and that is this: that the fact that the family that has spent £20,000 on legal costs and then comes to mediation is precisely the family that we're trying to capture in the early gateway triage. You know, that they're the ones who we think should be being diverted straight into mediation, so that they won't be spending £20,000 on legal costs. But I do think that there is a real there's a gap between those who can afford mediation and those who would otherwise qualify for funded mediation, and you know those for whom the cost of mediation is a disincentive. And I personally think we all need to think more about how we ensure that that cohort is captured and provided for. And of course, you know, I'm sure the mediation community would want to see better state provision or legal aid provision for mediation. But until that happens, and until that conversation has been taken forward, we still have this gap between what's available in court and what's available in mediation for those in the kind of I don't want to call them the middle income, but the sort of the bracket between those who could afford it and those who would otherwise qualify for state fund.
Yeah, I think there's a lot of variation across the country and provision, and we're looking at it, and it'll be interesting to see how long the current voucher funding lasts, and then what will happen after that. Is it just a one-off, or are we going to see this as a continual fund to support mediation? So we look forward to that. Yeah. I know you've got to run now. I just wondered if there's anyone's got any burning one question before Mr. Cobb leaves. No hands are up. Well,
that's just as well. So I think my first case is probably waiting.
That's what I thought. I thought I'd just push it a little bit more. Okay. Well, thank you for giving us your time and speaking to us as mediators. I think it's really valuable that we do hear the views from you in the direction of travel that we all need to be thinking about. So thank you.
Thank you very much indeed, and I look forward to carrying on the conversation with you all. As we go forward. This is, as you know, quite a long project, and there'll be plenty of opportunity for us to talk again. So thank you very much indeed. I'm now going to leave. I hope you enjoy the rest of your day. Thank you.